Artificial intelligence is the simulation of human intelligence in machines that are programmed to think and learn like humans. It involves the use of algorithms, statistical models, and computer programs to perform tasks that typically require human intelligence, such as recognizing speech and images, making decisions, and translating languages. There are different types of AI, including rule-based AI, which uses predefined rules to perform tasks, and machine learning, which involves training a model on data to make predictions or decisions. It will not have gone unnoticed that artificial intelligence tools are picking up and making the headlines like crazy. We see tools like ChatGPT, everyone will have heard of it, as well as Midjourney, who are taking over by storm. And I'm sure that you will agree that you'll have many questions around it. Surely I do. So I'm very pleased to be here today with Rasha Al-Arda, who is a partner at Altamimi & Company, to answer a number of questions in relation to the legal implications around the artificial intelligence tools that are on the rise at the moment. Rasha, thank you so much for joining me today.
Thank you, Barbara. Thank you so much for having me. And I'll be really happy to talk about this topic, this really very important topic. I'm actually glad that you brought me in here instead of asking ChatGPT to get to the answers.
We did consider that, but we do believe that things like this are actually not, been able to be taken over by artificial intelligence. We need humans for that, and in fact we need someone who can shed some light on the legal implications. As a lawyer in the intellectual property department, I would like to ask you, if we create content on artificial intelligence tools like ChatGPT, for example, then who would own the copyrights of that specific piece of content? We see ChatGPT as an example, or Midjourney, as I mentioned, where you can create images on an artificial intelligence basis. But if I would then use it, is it mine or is it the system's?
Well, this is a very good question, Barbara, and it is actually the core question that is being asked now. It's not something new. It's not a new question. It has been asked for quite a while, starting from 2016 when the AI-generated content has started. But now, with the growing use of the AI-generated content, this question has become more and more relevant. To answer this question, actually, it's not a black or white answer, to be honest, but we need to get back to the core of the copyright, basically, which is who owns the copyright and what is the material that can be protected by copyright. And generally, in copyright laws, you need to have a human element. There need to be like a human involvement in the creation of the work so that you can say there is a copyright on that work. So we are talking now about machine generated content. So there are two, let's say, ideas, which is either we would say that these contents that are created by the machines are actually not owned by anyone. So basically, there is no copyright over it, and anyone can freely use it. And you may say that, no, the person who made the query is the owner of this copyright. But here you would need to look at, okay, so what is the involvement of this human in creating this work? It's not substantial. There should be like a substantial involvement of the human being. Another would say, okay, it could be the developer of the software because it was created by someone, so this developer would be the owner. Well, you would think of it, yes, maybe, but not necessary because, the human element there was for the development of the software, but not each content that's coming out of it. So there are like a number of elements to consider. There is no specific answer yet. It is not something that has been questioned by the court in our region. So it's going to be something for the court to consider, actually. But the other issue that comes from this question actually is, you know how this content is created by machine, but it is created based on a number of content that it already exists. Yeah. Because this is how it works. Like, you collect several images of, for example, and the machine will do, or the AI machine will do a kind of analysis and they create a new work. So there is another issue that is created here, which is like, what about the copyright of the existing works? And this has actually is asked now. I think there is an artist in Australia, I think, who actually claiming copyright over her work. She's saying that her work is everywhere in all these AI machines, and the new work is resembling her work, actually. So whether there will be a copyright infringement or not, this is another question or another area that it is now being asked.
Yeah, and it's something that is clearly on the rise, and we see also in the news only this week there was speak of agencies, for example, social media agencies, or even suggestions made on the social media channels like Instagram. If you wanted to do, a side gig, now is your time, because you just use ChatGPT, you type in your post idea, you get a post and you sell it. Yeah. So where does that sit? And if you sell that piece of content as an agency and say, oh, I've got a great post for you to use for your company, here you go. Do you need to cite the author, where it's coming from, i.e. the artificial intelligence tool that you've used, or?
Well, this is a good question. In terms of citation, generally, it's more of let's say an ethical thing, to cite where you get it from, and for the reference of it. In the law, like when you quote from somewhere, yes, you have to say and to attribute this work to the author of it. And again, it's linked to your first question, who owns it? So if we're saying that the ChatGPT is the owner, or the AI machine is the owner, then you have to cite it. But it's more of a reference thing that, yes, you got this from this AI machine, and it's not, or software, and it's not like something that you have created.
Yeah, and students are now becoming very clever with this tool as well, and we see them use it to create essays, for example. Professors are struggling because they see really well written pieces now appear from students that they thought did not have that capability. There are tools available where they can apparently check also whether content is AI generated. But if they check this and say, in the example of this Australian artist, then what do we do with that? So you have the knowledge that a piece of content was AI generated, and then what? Can we do something like legally to take action, or?
Yeah. Well, again, like, if you are, if we're talking about, like, a student using this AI machine, they didn't copy someone else. They just, used a machine to help them doing the work. So they didn't do it themselves. So it's more of, again, like, this ethical obligation. Like exactly. Yeah. But they didn't copy it from someone else. Yeah. If we're going to talk about infringement, there are criteria. Like, there is a test to say this is a copyright infringement or it's not a copyright infringement. And, you would need to look at it from how much was copied, what was copied, does it resemble the original work? And this is where you go to get, like, whether it's an infringement or not. But, it is AI machine that creates a new work based on a number of existing works. I'm not sure how much they copy, from the existing works. And this is where actually the risk lies. Like, whether they are copying a substantial amount of the existing works, or not at all. It's just like, because, with copyright, there is the protection comes, we can all have the same ideas, but the way you express this idea, this is what is protected. So basically, even if you put an article somewhere you write about copyright, for example, someone else can write about copyright as well at the same time. It's not necessary that this is copying, because it is, the idea. The people are talking at the same idea. So there are a lot of things to consider and to see if there is an infringement or not.
It still sounds like a bit of a gray zone. So what sort of advice would you give to IP Council, especially in the MENA region?
Well, I would say it's an advice not only for the IP councils, but it's in general, because, I think with all these AI content generating systems, things becomes easier, and you would want to use it, because we all say work smarter, not harder. So things are now, it makes it very easy for you to generate any piece of work that you want, any piece of art that you want, but you have to be really conscious, and you have to be really careful on relying on such works. If you are intending to use this work, let's say, and to use it for yourself, you need to be careful, because maybe some other people start using it, then how you will claim copyright over it, because as we said, there might be no copyright protection for it. So you will not protect it, basically, and anyone else can use it from you, and you would not have any course of action to take against them. So it has to be really dealt with carefully. There are some ideas of don't take it as is, but still do some effort from you. Work on the first product that gets from the AI machine, work on it, and then you will have more of a human involvement in the creation, and then you will get a better protected work.
Yeah, I think that's fair. So use it, make use of it to work smarter and not harder. I would totally agree with that. But add something of your own to the content that you get from those
you have
machines.
to be careful. It's still, as I said, it's still really a fine line in terms of would it be protected, would it not be protected, would you be stepping on third parties' rights or not? So it has to be really addressed carefully.
Yeah, absolutely. Thank you very much, Rasha, for joining us today and for your helpful insights.
Thank you so much. Thanks. Happy to be here.